would be deemed a public servant. The survivor has been following with the case, and protests had been held earlier at the High Court. Today in the morning, there were protests that were held at the Supreme Court as well. Meanwhile, the Solicitor General has in fact argued on behalf of the CBI. It has said that it was an act of public servant and that this is a horrific case of rape that was done to a child. He said the victim was around 15 years, 10 months when the crime was committed. My colleague Savya, in fact, joins on with us from the Supreme Court. Savya, there is a lot of to and fro that's going on between the justices as well as the SG as well. The big argument being that there have been lapses with regard to how the HC has in fact viewed the provisions when it comes to the IPC sections 376 and also at the same time the section 5 and 4 of the POCSO Act. More importantly, whether Sengar was in fact looked into as a public servant or not.
That's right, Varghese. See, the entire argument going on right now is regarding what is the definition of a public servant. In fact, in the petition which the CBI had filed to the Supreme Court, they had mentioned about L.K. Advani that in one of the hearing, the Supreme Court itself had accepted that the MLA or a MP can be considered a public servant. Now, for viewers, to simplify things, the Solicitor General have said that the POSCO Act offences can be broadly classified in two categories. Now, what are the two categories? Penetrative sexual assault is per se an offence. 4 provides for punishment. In 2019 amendment for punishment, it was not less than 10 years max and life in certain circumstances. There's aggravated form. The categories are that if a person is in a dominant position, then it is considered an aggregated form under which the CBI carried out the investigation, and as per the sections of POSCO Act 5 and 6, he was given life imprisonment. Now, the Solicitor General Tushar Mehta also pointed out that the public servant not defined in POSCO Act by reference, whatever defined in IPC will be the definition. Every word used in any statute is not mechanically getting definition. Public servant would mean a person who is in a dominant position over child. Now, the Solicitor General also pointed out, giving a reference in A.R. Antoli, the SC has said that MLA is not public servant, but was that in facts of the case. When cognizance was being taken, he raised issue about 1947 PC Act, which did not have definition of public servant. Court construed in context of the act whether sanctions was needed, and CGI had said that, see the intent, the court did not want to grant him protection of being public servant. So clearly a lot of to and fro at this particular time going on, where very importantly the Solicitor General Tushar Mehta had pointed out that at the time when the incident happened, the victim was a minor. The victim was around 15 years 10 months old. She was not of 16 years old, and under these circumstances the CBI has very efficiently carried out the investigation. They have submitted all their findings and evidence, and under which the conviction has taken place, and the Solicitor General clearly disagreeing with the decision that was given by the Delhi High Court regarding the suspension of the life sentence of convict Kuldeep Singh Sengar. Back to you.
Also, there is interesting enough as that to and fro in fact goes with regard to whether the person was a public servant or not. Now, they say that because it's a POCSO Act that is there is no need to find out what the position the person in fact holds. The POCSO Act becomes quite relevant in the case. Is that how the SG is in fact arguing?
Well, that's right. See, the POSCO Act itself becomes quite relevant, and the Solicitor General Tushar Mehta, that is the reason why pointed out that there are various stages of the POSCO Act, and the findings and the evidences which has been provided by the CBI in the case, and under which on that basis the trial court in fact have convicted Kuldeep Singh Sengar, finding him guilty and finding him that the rape was conducted in in an aggravated manner, and that is the reason why life sentence was given to convict Kuldeep Singh Sengar. And that very point Solicitor General Tushar Mehta have been highlighting, that the stricter section of the POSCO Act has been implemented in the case because the victim was a minor at that particular time, and also Solicitor General pointed out that how the decision that has been given by the Delhi High Court can have an adverse effect on the mental health of the victim, because there is a continuous threat to their life, because it is out in open what has happened with her father, what has happened with a lot of family members of the victim, how they were killed. Her father was killed in the police custody, and several of her relatives lost their life in road accidents. So under these circumstances, there is a continuous threat to the life of the victim. And Solicitor General Tushar Mehta also pointing out and giving a definition of the public servant, because that particular procedural lapses was exploited by the lawyers of Kuldeep Singh Sengar when the matter was heard at the Delhi High Court, and the Delhi High Court stating that the MLA or the MP does not come under the category of public servant, as it has not been mentioned, and that is the reason why Kuldeep Singh Sengar's sentencing should not come under the stricter section of the POSCO Act, and rather it should come on the lesser strict section of the POSCO Act, that was section 4, and that amounts to 10 years of imprisonment. And since Kuldeep Singh Sengar had almost served around 7 to 8 years in prison, and that under these circumstances the bail was granted to him, and that very point has been highlighted by the Solicitor General Tushar Mehta today. And a lot of to and fro is going on between the CGI and the other justice and the Solicitor General Tushar Mehta regarding what is the definition of the public servant in this case.
Well, also we have in fact come to know that there has been an effort on the part of the CGI to in fact understand the case as such. He said that, interestingly enough, he said that let's assume for the sake of argument that he's not a public servant under Section 5, then he falls under Section 3. The amendment did not create a new offence but merely enhance the punishment. So the argument has also been going on that there should be 20-year punishment that should be attracted on this aspect as well. In fact, we have some big news that's coming in. Supreme Court stays HC's order on Sengar's bail. Supreme Court stays HC's order on Sengar's bail. This is the big story that we are in fact breaking at the moment. Supreme Court stays HC's order on Sengar's bail plea. Supreme Court has been hearing the arguments. The SG had in fact argued with regard to the situation on the ground, where he in fact said that there has been an err on the part of the HC on this particular aspect of whether the person is a public servant or not. For more on this, I'm joined by our input editor, Brijesh Pandey. Brijesh, finally they have the Supreme Court going ahead and in fact placing a stay on this order, probably looking at all the legal issues that would have surfaced in this, also the misses that the High Court had. How do we in fact see this particular aspect of the stay? Because there could be a stay on the order, but the case is still going to go on.
Varghese, because you know, the order of the Supreme Court will again be challenged, and I think the proceedings will go on. But I think, you know, the big breaking which is coming out is that Supreme Court has stayed the Delhi High Court's order on Kuldeep Singh Sengar's bail, and you know, the Supreme Court clearly has gone with the arguments which has been put forth by the CBI side, which was led by Solicitor General Tushar Mehta. And you know, Tushar Mehta in its argument made it very clear that there were two dominant narratives. One, the CBI, the Delhi High Court did not took into the cognizance about the fact that into Section 376 of the IPC and also Section 5 of the POXO Act. They also said that the CBI had proved beyond shadow of doubt that Kuldeep Singh Sengar was at that point of time a public servant. Apart from that, they also said that one of the things which which the court has to take into consideration was that the victim at the time of rape was 15 years and 10 months old. Therefore, she was clearly a minor. And once you take into consideration that the accused had a dominant status in the society apart from being the MLA, then it makes it an aggravated assault sexual assault case, and the court had said that the reason why POCSO was invoked was that the victim was a minor. The SG also went on to say that section 376, which is a rape section under IPC, has two parts, and then rape by someone who enjoys a dominant position, then the minimum prison is 20 years or can extend to the biological life. To which the Chief Justice of India, Surya Kant, asked that are you trying to say that if the victim is minor, then the High Court order is not justified because the accused cannot be considered a public servant? So what they're saying is that the act itself, the fact that a minor was raped, is a clear-cut given scenario that the concerned accused should be tried under Section 5 of POCSO and also under Section 376 of IPC, and also the fact that the accused enjoyed a dominant status also points to the aggravated sexual assault. Therefore, the minimum sentencing which we are looking at is 20 years for sure. I think they requested the Honorable Supreme Court that the stay should be granted, and the court, inclined with the argument put forth by the Solicitor General of India, agreed, and the Supreme Court has ordered a stay on the Delhi High Court order. It's a big breaking as far as in the Unnao rape case is concerned. If you remember, when the judgment of Delhi High Court had come out, it sent shockwaves across the country, and there were a lot of protest which was there. The victim came forward and said that the way judgment was delivered is a clear case of subversion of justice. And if you look, I think, after this, the role of the investigating officer, which was clearly held in the fact that he was not able to perform his duty clearly by both the lower court and the High Court. Varghese?
Also, interestingly enough, a lot of interesting arguments have come with regard to the question of whether retrospectively something can be applied or not. The question about ensuring that the very act itself was perpetrated on a minor. So the question of whether the person is a public servant or not, the fact that it was a crime that was committed on the minor itself brings in the stringent provisions of the POCSO Act. So all these clearances have been in fact put in place. Thereby, now how do you see it in fact moving in the arena? Because we had seen a series of protests. The stay order could be the first kind of victory for those who have been supporting the survivor.
Well, I think, this makes the future very difficult as far as Kuldeep Singh Sengar is concerned, because, the fact is that the Solicitor General also pointed out that this particular case, when it was being argued in the Delhi High Court, they said that the lawyer had argued that in the A.R. Antule case, which involved corruption, and this was the parallel which was given in the case of Kuldeep Singh Sengar. But the fact of the matter is that the Kuldeep Singh Sengar case also falls under the POCSO Act. So whether he is a public servant or not becomes irrelevant. If he is tried under POCSO Act, then the minimum which you are looking at is 20 years, and it can also be extended up to your biological life, clearly meaning that you have to spend the rest of your life behind bars. What made it aggravated case was the fact that the accused enjoyed a dominant status, and also the fact that he is facing another case and is behind bars for the murder of victim's father. So I think, the court, the apex court was seized of the matter, and hearing on all these detailed arguments which has been put forth by the CBI, by the Solicitor General, clearly put a stay on this.
Right. We are also joined in by Brinda Adigi, a social activist as well. Brinda Adigi, how do you in fact react to the first part of it? That is the stay that has been brought on that order where the High Court had given bail for Sengar in that particular case. And how much does it mean about law, the rights of women, and how much does this particular case in fact look at the overall safety?
That's the biggest news as of now. And I think we are seeking it now legally there, on papers. Let's see what it comes out to be.
All right, ma'am.
Thank you.
मैं एक सिंगल कर लेता हूँ. मैम इधर आ जाइए. मैम इधर आ जाइए. मैम यहाँ पे. बस.
Brother, sorry, we had a bite that was coming in. I was asking that how much has this stay order in fact goes when it comes to the fight for women's security in this country?
Yeah, I'm glad that the stay order has come in through, and this reiterates the faith and confidence of the citizens in the Supreme Court. But the next question would be, how many citizens, how many times will have to approach the Supreme Court asking that you stay the order down when the laws are the same, constitutional guarantees are the same for all citizens from every court? from the lowest court to the highest. Should the judges not follow the letter of law? Here there was political influence and institutional failure. And the survivor is being asked to fight against these two. I do hope the Supreme Court will also put in a line that along with the trial of the convict Kuldeep Sengar, the system must also be tried.
Well, interestingly enough, you were saying about institutional failures that we are looking at, but as you see, most of them start with the Sessions Court, and probably even at the High Court, they do not have the wherewithal to go to the Supreme Court and in fact challenge something like this. This case, of course, having a support from a lot of people and a lot of background that is there, where they have decided, and the survivor being strong enough to take it up till the Supreme Court. So how much of it requires a deeper understanding within the lower courts when it comes to such cases?
More than the understanding with the lower courts, we want to ask this question: why is there political interference and influence? Why? Should not every political party say, if a member of my party has indulged in any crime, whether it is against children or women or any Dalit, we will not interfere over there. Let the courts take action. The next question that I want to ask is, why are judges afraid to pronounce the verdict and judgment in line with what the law says? You have a law. That is your job to uphold. You are being paid by the paymasters to uphold that law and bring perpetrators to justice. So what are you afraid of, even if there might be a political interference? And my third is, you have told us, or you have, assured us that victim and witness protection will be extended to you by the system and its functionaries. Why is it that your process, your procedure is due process and procedure is being now held against the survivor to say, now you show us what is this perception of threat? Why should she show? Why should we be forced to show all these things? And that is why I'm saying that our law says that, you must not question judges, but as the paymaster, I want to question a sarkari naukar. That is my right, to hold them accountable. So whichever court you might be there, you must be held accountable to the verdict, to the judgments or the orders that you give.
Where do you in fact see with regards to the law, the reform in the law as such? We have several laws in place, but there is something that is lacking that could be in fact giving it the teeth that it requires. Where do you think those reforms should be placed in?
The convergence. The police, the prosecution and the judiciary seem to be working at loggerheads. Is it not their duty to converge? Is it not their duty to ensure that the police brings in all the evidence, the prosecution establishes that evidence and argues accordingly, and then the judge sees and says, yeah, I have all of this before me, and this is the law that has been violated, and here is the evidence before me. I will pronounce that judicious judgment. What is stopping them from doing this? We are not asking them to be activists like us questioning every wrong. We are asking you to just follow the letter of the law in the spirit of the law that has been enacted. Is that asking too much? I'm doing it out of passion. You are being asked to do it because you're paid for it. You wrote an exam. You came there. You said you want to do this work. And so you are there. If you are not accountable and you keep holding survivors, victims who are dead and gone, you are holding them accountable to a procedural lapse, where else can we go? We have courts as our last resort. Where else can we go?
The other part of it is that how much of it is falling on the shoulders of the survivor to in fact prove that the person has been wronged. How do you in fact see that kind of a pressure that keeps building no matter how the laws are?
That is a shame. 140 crore Indians must hang our heads. Hang our heads in shame that a survivor is being asked to fight against systemic failure, political clout, patronage, and the entire system going against her. We are asking the survivor, okay, you have been raped, gang raped, you have been threatened, you have been intimidated, your family has been bumped off, and now you fight all these people to who your taxes pay their salaries. Can you imagine? In mother of democracies, asking the survivor to do, not asking, forcing her to do it. If she and her supporters had not gone on dharna, not gone and demonstrated and protested, do you think the Supreme Court would have responded in the same manner? And like you asked in the first question.
In fact, we are now joined in by Rekha Sharma, former NCW chief and Rajya Sabha MP. Rekha Sharma, your first reactions to the Supreme Court staying the HC's order on Sengar's bail?
I welcome this order of Supreme Court because now I think it should be reversed also, the High Court's order, because Mr. Sengar needs to be in the prison and should be sentenced to life. The crime he committed was not small, and CBI rightly went to the Supreme Court, and I think the Supreme Court's order will give some kind of relief to the victim also now.
Well, Rekha Sharma, how do you in fact see, there's a lot of questions being asked, like how much a fight a survivor will have to take, especially going through the courts against powerful people who have wronged them. Now, this has been in the media eye. There are a lot of such stories about survivors who have to fight powerful people but don't come out in the media. How do you in fact see that our laws have to be reformed to protect the survivor, and that the fight shouldn't be that of the survivor, it should be that of the state trying to give justice for the survivor?
It's really sad that survivor had to go through, and people who stood by her did commendable job in this matter. But I must say that the High Court's order were not right, and justice should be given to the victim as she was rightly saying that this person need to be under arrest forever. He should not come out. मुझे लगता है कि हाई कोर्ट के ऑर्डर ने जितना पेन और दर्द दिया है विक्टिम को, और विक्टिम के साथ लोग खड़े हुए और हम जैसे लोग जो हमेशा लड़ते रहे इन सब प्रॉब्लम्स में, उनको जितना दर्द दिया है हाई कोर्ट ने, मुझे नहीं लगता कि ये राइट डिसीजन था हाई कोर्ट का। और इस तरह के डिसीजन कई बार बिलीफ नहीं करने का मन करता कोर्ट्स पे, अगर ऐसे डिसीजन कोर्ट्स देते हैं तो।
So, what is the kind of reform that you are looking when it comes to laws protecting women, especially those who faced assaults like this? Now, here, this case with regard to the POCSO acts are also there because the crime happened when the survivor was a minor, and then you see that person fighting it out.
धन्यवाद देना चाहूँगा, पीड़िता धन्यवाद देना चाहती है। पूरी देश की संवेदना सुनी सुप्रीम कोर्ट, और अभी उस ऑर्डर पे स्टे लग गया है, और सुप्रीम कोर्ट सख्त आवाज में ये मतलब आदेश दे दिया है निचली कोर्टों में कि अभी किसी भी मामले में उस अपराधी को जेल से बाहर नहीं निकाला जाएगा, और जो ये ऑर्डर है उस पर स्टे है। अपोजिशन को उसमें काउंटर एफिडेविट फाइल करने का टाइम मिला है, और तब तक के लिए उसको किसी भी मामले में छोड़ा नहीं जाएगा, बाहर नहीं निकाला जाएगा। ये सुप्रीम कोर्ट का आदेश है और स्टे है हाई कोर्ट का ऑर्डर।
संतुष्ट हैं इससे फैसले से?
अभी तक के लिए जो इंटरिम प्रोटेक्शन मिला, राहत मिला है, उसके लिए हम लोग संतुष्ट हैं। आगे भी सुप्रीम कोर्ट से पूरी न्याय की उम्मीद है, न्यायपालिका पे भरोसा है पीड़ित परिवार को और पूरे पीड़िता को। मैं एडवोकेट हेमंत कुमार मौर्य, और एक एडिशनल मैं कह रहा हूँ कि उस परिवार को अभी भी थ्रेट मिल रहे हैं। उसके जो चाचा हैं 9 साल से जेल से बाहर नहीं निकल पाए हैं, फर्जी केसेस में उनको फंसा के रखा गया है, उसके प्रॉपर्टी को हड़पने की कोशिश की जा रही है। दूसरी बात, आज सुबह में मेरी फ़ोन आई उसके रिलेटिव का, जिसका मैं नाम डिस्क्लोज नहीं करना चाहूँगा। उसका माइनर बच्चा है, उसके स्कूल का जो एडमिशन है उसमें जो 9th क्लास से जो बोर्ड में रजिस्ट्रेशन होता है, वहाँ पर उन्होंने स्कूल वाले रजिस्ट्रेशन नहीं करने दे रहे हैं। अलग अलग उनके जो अपराधी है उसके एसोसिएट्स द्वारा इस परिवार को अलग अलग एंगल से परेशान करने की अभी भी कोशिश की जा रही है, और बाहर निकलना खतरा।
कौन दे रहा है?
ये अपराधी के एसोसिएट्स हैं, जिनका नाम मतलब तो नहीं, लेकिन वो अलग अलग तरीके से। नहीं, सुप्रीम कोर्ट में लिस्टिंग हुई थी, सीबीआई ने फाइल किया था, उसके जो हाई कोर्ट में रिलीफ लेता है। बिल्कुल बिल्कुल, ये चीज़ तो मेंशन नहीं कि ये सेपरेट चीज़ है, उसके लिए हम जो लीगल प्रोसीजर है वो हम आगे देखेंगे।
ठीक है, थैंक यू सर। सिंगल आईडी कर लेते हैं। चलो भाई, सरफराज सर क्या कुछ कहेंगे? जिस प्रकार से ऑर्डर आया है, सुप्रीम कोर्ट ने स्टे दे दिया है, उसके लिए आज क्या बताएं?
सुप्रीम कोर्ट को धन्यवाद। देश की न्यायपालिका को धन्यवाद। विक्टिम परिवार को पूरा ये आशंका है कि अगर अपराधी कहीं से भी छूट जाएगा, उसका गिरोह तुरंत सक्रिय हो जाएगा और अलग तरीके से उसका मोटिवेशन जो बढ़ेगा, उसके गिरोह के लोगों का बढ़ेगा। जो बचे खुचे परिवार के लोग हैं उसको भी मार और मिटा दिया जाएगा।
विक्टिम के चाचा हैं, किस प्रकार के?
विक्टिम के चाचा के
Rekha Sharma, there was in fact some of the reactions coming in from the lawyers who are fighting for the survivor. They were saying that there's so much of pressure on the family on different angles for them to drop the case and to stop the fight. This is exactly what I would in fact also try to take concern with. There should be some kind of a protection law that would help the survivor fight to not face the kind of pressure that the survivor is facing now. Do you want that kind of a reform within the structure of law? All right. We will in fact try to get back Rekha Sharma in a while. Well, the big story that we are tracking at the moment, SC stays HC verdict on the bail that was in fact given to. In fact, let's listen into some of the reactions that are coming in.
It is a positive sign that they are saying verbally, at least in verbal discussion, it has come out that Supreme Court said they are inclined to give justice, inclined to stay the order, bail order. I think that's the biggest news as of now. And I think we are seeking it now legally there, on papers. Let's see what it comes out to be.
Well, I think we are hopeful now that things will move, and we're very hopeful that justice will be given to the Unnao victim. फांसी की सजा मिलनी चाहिए एक बलात्कारी को, ना ही कुलदीप सेंगर बट आगे भी पिछले केसेस में भी जो भी एक नया लॉ आना चाहिए जिसमें बलात्कारियों को कैपिटल पनिशमेंट मिलना चाहिए.
My colleague Sabir Sarji, in fact, still joins us with more. Sabir, a lot of reactions coming in with regard to some of them saying that they are happy that the bench has said that they're inclined to go ahead and favor the stay of the order with regard to the High Court. But a lot of questions have been asked about where the lapses have been. The SG, in fact, making sure that some of those lapses are even highlighted with regard to it. Questions about how reforming the law and all is there. But then, also, the lawyers coming out and saying that the survivor's family is under immense pressure from several quarters on trying to drop this case. That is something of concern.
Well, that's right, Varghese. See, regarding the definition of the public servant, the Chief Justice of India clearly stated that it requires a wider discussion, and soon the discussion will take place. But what is important right now is to put a stay on the decision that has been given by the Delhi High Court, and the Chief Justice of India told that in other cases, if a High Court has given a bail, in normal cases the Supreme Court would not intervene. Now, but this particular case was different because the convict was already in jail because of other cases, and that is the reason why the Chief Justice of India had decided that to put a stay on the decision that has been given by the Delhi High Court. Now, the court also considered the fact that how there is a continuous threat to the life of the victim, to the life of the victim's mother as well as the victim's husband, and not only once but in several occasions. See, the victim and her mother continuously has been protesting in different areas of the national capital, whether it is in front of the India Gate, whether it is front of the Delhi High Court. They have been on the ground, they have been demanding justice. So they also have been claiming that there is a continuous threat to their life because in a manner in which her father was killed in police custody, her other relatives were killed in road accidents. So under these circumstances, there is a continuous threat to their life, and that very point was highlighted by the victim's lawyer today after the Supreme Court has given its decision. Now, the victim's lawyer also highlighted that how her other relatives also have been receiving threat messages as well, and their life is continuously under threat, and the victim, that is the reason why from the court side security has been given to the victim and her family members. Now, it's a massive, it's a big win for the victim and her family because I have spoken to them. They have been going through a mental trauma. They have been completely broken after the decision was given in by the Delhi High Court. They in fact said that once the decision came in from the Delhi High Court, there was celebration in front of the residence of Kuldeep Singh Sengar and how his supporters celebrated. So all these things have had a very bad impact on the mental health of the victim, and that very point have been highlighted by Yogita Bhayana, who has been with the victim from very day one, and this has been a big win. In fact, this has to be done, and very importantly, the Supreme Court has very categorically mentioned that since the sexual assault was on the aggravated way, so under these circumstances, it hardly matters whether the person who has done it is a public representative or not. So that is the reason why the Supreme Court has decided to put a stay on the decision that has been given by the Delhi High Court, and there has been definitely a lot of lapses. There has been procedural lapses, there has been lapses as far as the investigation is concerned, and that is the reason why the Solicitor General Tushar Mehta very categorically pointed out in front of the bench that when the incident happened, the victim was 15 year old and 10 months old, and it has been traumatic for the victim as well as for her family members as well. Back to you.
In fact, one more thing that has in fact come from this entire argument is with regard to how the case has been in fact fought in these in the High Court, and at the same time how it's been fought in the Supreme Court as well. The CBI in fact seeing that it has brought everything that in fact points to the conviction. It has in fact left no doubt with regard to the evidence that they have on this. Interestingly enough, the person still is in jail. Sengar is still in jail in the murder of the father of the survivor, and this particular charge tends to be something that was dropped out. So that itself had some kind of, not kind of a resonance that would we look at when these cases are filed. So that itself is something that the CBI also wanted to highlight.
Well, very rightly, see, in fact, the CBI from day one have maintained that they have carried out a very thorough and deep investigation. And now Tushar Mehta, the Solicitor General who was representing...
आराम से हो जाओ, मैं जा नहीं रहा, चोट ना लग जाए कहीं, मैं अंदर ही आ जाऊं, अंदर ही आ जाऊं तो बेटा, हाँ अंदर आ जाइए, ठीक नहीं, अच्छा नहीं लगता ना ऐसे, चोट लग जाएगी किसी के, भाई साहब चोट लग जाएगी किसी के, चोट लग जाएगी, चोट अंदर आ, अब हो गया, सेटल हो गया सर, नहीं हुआ ना वो, चोट लग जाएगी, मैं अंदर आ जाइएगा.
Sir, we had to just cut you off just when there was a bite reaction coming in from the lawyers. Yes, you were going ahead and you were speaking about the CBI's investigation into the case.
Well, that's right. See, the Solicitor General Tushar Mehta pointed out in front of the bench that the CBI had carried out its investigation. The CBI had put across its findings and evidences to the bench, and based on these findings and investigation, the trial court had convicted Kuldeep Singh Sengar and had sentenced him to life imprisonment. So that very point time and again was highlighted by the SG that the CBI has done its investigation properly. Meanwhile, both the lower court both the trial court as well as the Delhi High Court in their order had mentioned that how the IO did not carry out the investigation properly, and that in fact had caused a disadvantage to the case of the victim. In fact, in the order, the trial court and the Delhi High Court also acknowledged that how the CBI was focusing more on the case, on the other case which was related to it, the death of the victim's father, and spent too much time on that. In fact, the court also highlighted that how the CBI took a lot of time to file its charge sheet. Though the Solicitor General Tushar Mehta time and again pointed out that how there has been stages of POSCO Act, and he clearly defined it and said that the sexual assault was on a aggravated manner, and under these circumstances there should not be suspension of the judgment, and that is the reason why he appealed to the Supreme Court to intervene and put a stay on the decision that was given by the Delhi High Court.
All right, Sabir, now one of the key factors being is that this becomes as quite a victory for those who have been fighting for the survivor, and especially when it comes to the people, especially the people who've been protesting on this as well. We have some big news that is in fact coming in. SE stays its own November 20 order on Aravallis. This is the big story, the other big story that's happening in the Supreme Court. SE